I'm here on Miss Gill. She set for a bond today, and
Is she in
so
custody?
she is. Yes, Your Honor. And she has one pending felony, but she already has she's out on a bond for that one already. She just has no bond set in this case.
I see bond sets. I see the FSGI is at 1,000. Yeah.
Okay. I talked
It
to
must have just gotten set. I don't know.
Okay. Is it a PR bond?
No. It's a
Okay.
shirt.
Okay, then if we could review it today, is that possible?
Absolutely. Do
Okay.
you mind, Deputy, that you going? Do you need a translator?
No.
Do you mind me bringing up Miss Gill? All right. Good morning, Miss Gill.
Good morning, Your Honor.
I wanted to bring you out because we're talking about you, and it's only fair that you get to hear what's transpiring since
Hold up.
these are your cases.
This is where
Yes,
the
sir.
case
I want you to
suddenly
know,
gets
I don't know
serious.
anything about your case.
Before
All I
the
know is that
defendant can
you've now,
explain her
as of
side, the
320,
judge immediately reminds her of her right to remain silent because anything she says could potentially be used against her. Now we're hearing an allegation of a hit and run, with the complainant claiming the defendant struck her vehicle twice and then drove away. But the big question is this: was that second impact accidental or was it intentional? Because that detail could dramatically change how the court views the entire situation. What do you think? Does the evidence sound like a simple traffic incident or something much more serious?
Stated that she was driving southbound on the East Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallsville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited, and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time. The
So are
complainant,
you telling me that now it was intentional?
the complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who.
Wow. This judge is making it crystal clear that the court is not treating this as an isolated incident. According to the court, there are already multiple open cases and prior allegations involving serious offenses. And now another failure to stop and give information case has been added. That's why the judge is focusing so heavily on public safety and taking away her privilege to drive. But remember, these are allegations and court proceedings, not a final determination of guilt. The bond decision is about managing risk while the case moves forward. Do you think raising the bond from $1,000 to $5,000 is justified here? Or is the judge going too far based on the defendant's history?
In a motor vehicle, and now an FSGI. I am taking away your privilege to drive. You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt. I can have a contempt hearing. I can have a contempt.
After.
Finish.
I'm so
please.
sorry.
Finish.
I'm a commercial driver.
Really?
Yes.
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. I truly am at a loss with the attitude.
Okay.
Truly.
Okay.
In this case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally. Because allegedly hungry and covered. So now, this is an affidavit, and I hope that you take it seriously. Because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor.
May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. Has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and she is willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100. And
So I appreciate your argument. She's technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what, Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road, is that you are a danger to the public, and your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always, I mean, really,
don't say anything.
how many people died this weekend on the road because of the reckless and wanton actions? All we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping
Don't say
me.
anything.
I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this. Okay? I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children. My children have trauma, okay? And I have no insurance for the medication, and I have not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
Okay.
I understand that, but at some point, your actions become your own, right?
You don't understand. I'm colored. You don't understand me. You don't understand me. If I was a different color, you would.
And now the courtroom takes an emotional turn. The defendant is connecting her current legal troubles to past experiences, trauma, and difficulties accessing medication, while also raising an allegation of discrimination. The judge, meanwhile, is trying to separate those personal circumstances from the alleged conduct that brought her back before the court. This is one of the most difficult moments in any courtroom, balancing accountability with the reality that people can be struggling with serious personal and mental health challenges. The question for viewers is this: should those circumstances influence how a judge sets bond and conditions? Or should the court focus strictly on the alleged conduct and public safety?